but contempt of court following his conviction and sentence for contempt. I will not set out the facts that the conviction and the sentence, as this is comprehensively covered in the proceedings and the rulings in which the conviction and sentence was entered. Suffice it to say that the court convicted and sentenced Mr. Masengeli to a sentence of 6 months imprisonment. Each sentence is suspended for 7 days to allow him an opportunity to find the contempt. The conviction and the sentence was entered following what the court considered to be a series of disobedience of court summons to appear in court to explain why the owner of habeas corpus on production of 3 Kenyans, that is the second to fourth petitioners, are not be complied with, despite the position by the petitioners that the 3 were arrested by police officers, by persons who were believed to be police officers. In sentencing Mr. Masengeli, the court was emphatic that the sentence imposed was a coercive order, as opposed to a punitive order, thereby leaving open a 7-day window to redeem himself by paying the contempt. Else, Mr. Masengeli would have been required to submit himself starting tomorrow to the Commissioner General of Prisons to start serving a 6-month sentence. Before embarking on the determination of whether or not Mr. Masengeli has satisfactorily found the contempt or not, it is necessary to have a clear understanding of what finding the contempt process entails. Finding process of the contempt entails. This procedure is not provided for in law, but it has been developed through experts. In Brack's Law Dictionary, the word punch is defined as to exonerate oneself or another of guilt. The dictionary illustrates that by saying the judge punched the defendant's contempt. The Supreme Court of India, in Praveen C. Shah versus K.K. Mohan and another, civil case appeal numbers 35th of 2000, extensively discussed what the punch process entails, making reference to its origins. The court stated as follows: punching is a process by which an undesirable element is expelled either from oneself or from a society. It is a cleansing process. Purge is a word which acquires implications first in theological connotations. In the case of sins, punching of such sin is made through the expression of sincere remorse coupled with the penance required. In the case of guilt, purging means to get himself cleared of guilt. The concept of purgatory was evolved from the word purge, which is a state of suffering after this life, in which those souls who depart this life with their deadly sins are purified and rendered fit when having defiled enters. The court even went further to observe that merely serving a sentence for contempt of court may not be enough to vindicate the authority of the courts, and that the best result would be what the contemnor demonstrates. It would be when the contemnor demonstrates genuine remorse and seeks the court's pardon. That was a major consideration that this court took into account when it opted for a coercive conduct as opposed to a punitive conduct, as the intention of the court was not to punish Mr. Masengeli for the sake of it, but to ensure that the sentence restores the dignity and the authority of the court. And the court intended to punish Mr. Masengeli right away. It would have not included the purge order as part of the sentence. The Indian Supreme Court, emphasizing on the need to have a sentence that meets the object or the aim of the court, held as follows: purging process will not be treated as completed merely by contemnor and undergoing a penalty imposed on him unless he has obeyed the order of the court or he has undone the wrong. Next step is to seek pardon from the court concerned on the ground that he really had genuinely repented and that he has resolved not to commit any such act in the future. The apology tendered should impress the court to be genuine and sincere. If the court is being impressed in its genuineness, accept the apology, then it will be seen that the condemner has purged himself of guilt. The question thus becomes, having listened to Mr. Masengeli, is the court satisfied that he has sincerely and genuinely apologetic about the circumstances that led to his conviction and sentence for contempt of court? In its explanation, to exonerate himself, Mr. Masengeli stated on oath, giving an account in which he explained why he did not personally attend court on the 26th of August 2024, 29th of August 2024, 3rd of September 2024, 5th of September 2024, and 9th September 2024, including the date of the sentence on the 13th of September 2024. He gave reasons that he was torn between national security duties and his obligation to attend court. He did not, however, explain why he did not commit to attend court on the day he had actually indicated to attend, that is on 9th of September 2024. He was cross-examined by advocates for the petitioners, and my observation is that his answers appeared genuine. He was calm and polite. To crown it all, he pleaded with the court, stating that if he had been wrong or made an error of judgment in prioritizing other exigencies of duty over the court summons, he sought forgiveness and mercy from the court. He stated as follows, and I quote, "I want to apologize to this court and the judiciary for the events that transpired leading to orders of contempt of courts. I respect you and the good work you do to uphold the law. As a police officer, it is my duty to enforce court orders and ensure court orders are obeyed. I pray the court accepts my apology against the conviction and sentence I so pray." End of quote. This court is convinced that Mr. Masengeli regrets and is genuinely remorseful for the situation he finds himself in. It is not the intention of this court to punish a genuinely repentant man who has acknowledged his mistakes and offered an apology. His conduct today has restored the dignity of the court and the due administration of justice by attending court and explaining the difficulties that caused him not to comply and offering an apology for any of errors of judgment he might have made. His undertaking to always obey and enforce the orders of the court came out strongly. The court is fully satisfied that the purging process has infused in his mind, or in the mind of the condemner, Mr. Masengeli, the obligation to respect and uphold the rule of law and the due administration of justice. The supremacy of the law has equally been vindicated. To this end, I must arrive to the determination that Mr. Masengeli, through this purging process, has purged his guilt for the contempt of court, and thus both the conviction and sentence passed are set aside. I must, however, not end this deliberation without speaking on the need for all to respect and uphold the independence of the judiciary. It is the judiciary that guarantees adherence to the rule of law. Every Kenyan who means well for this country must fight for the independence of the judiciary so that judges can be allowed to make decisions based purely on law and the facts without the fear of reprisals, interference, pressure, or threats, whether direct or indirect. That is the cornerstone of democracy. It should be known to all that the independence of the judiciary is not for the judges per se, but for the benefit of the public at large. It leaves judges with the discretion to make fair and even-handed decisions meant to uphold the rule of law. Judges must never and will never hold. Judges will always hold government organs to account for adherence to the Constitution and the law, and it is the primary duty of the state to ensure judicial independence is protected. I am happy to note from the LSK that the 3 Kenyans, the subject of this petition, have been found. Having said so, and considering everything else, I am making my decision to recuse myself from the further proceedings of this case for personal reasons. I will thus be directing that this file be placed before the presiding judge for application to another judge.
Most obliged. My Lord, we just wish to state that we're very grateful for your patience and for having given us the opportunity to bring the court this court. We're grateful to note that the conviction and the sentence has been set aside.